Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare and life sciences. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the lawyers at Epstein Becker Green, a leading law firm that has decades of experience serving clients in the healthcare and life sciences industries nationwide.
Welcome back to another episode of Spilling Secrets, a podcast on all things related to trade secrets and non-compete law. Today, we're talking about securing key employees in healthcare M&A transactions. My name is Kate Rigby, and I'll be your host for this special crossover episode of Spilling Secrets and Diagnosing Healthcare. I'm an employment attorney in EBG's Boston office, part of the leadership of the firm's Health, Employment, and Labor Industry Group, and one of the hosts of Spilling Secrets. With me is one of my co-hosts of Spilling Secrets, Erik Weibust. Erik is a commercial litigation partner also in our Boston office and vice chair of the firm's Trade Secrets and Employee Mobility Practice Group.
Hi, Kate. And from the Diagnosing Healthcare team, I am Dan Fahey, a partner in EBG's Chicago office. I help private equity clients, investors, hospitals, health systems, and other providers navigate complex regulatory issues in connection with healthcare mergers and acquisitions. And I'm also a regular host of the Diagnosing Healthcare podcast, a monthly podcast that examines the business opportunities and solutions that exist despite high-stakes legal, policy, and regulatory issues that healthcare industry faces. With me is one of my co-hosts of the Diagnosing Healthcare podcast, Tim Murphy. Tim is a partner in our Boston office and helps private equity firms, investors, and other provider clients with health regulatory issues. Welcome, Tim.
Thanks, Dan.
All right. Well, I'm excited to get going on this. Like the diversity of the industry itself, and probably because of it, mergers and acquisitions in the healthcare industry take many forms and vary widely in the size and complexity, whether it's from multi-million-dollar mergers of pharmaceutical giants to the acquisition of a physician group, by a larger group or a private equity firm. There are myriad iterations. As part of those transactions, buyers tend to focus on a number of things, including transfer of IP, records, technology, equipment, real estate, and then, of course, integrating workforces and benefit plans as it closes. But an important issue that is sometimes overlooked is securing key employees post-closing. So today we're going to discuss that, particularly in human capital intensive industries like healthcare. So Tim, you and Dan both have extensive experience assisting with healthcare M&A deals. Can you tell us a brief overview of the types of transactions that are common in the industry, from the size of those deals to the type of healthcare organizations involved?
Sure. Thanks, Kate. I guess I'll start with, we're not in just the hundreds of millions, we're in the billions now on some of these transactions as they grow larger and larger. But the transactions really vary from those multi-billion dollar transactions to a couple $1 million for small physician groups or a small provider. They cross the gamut across healthcare, which can be a hospital transaction, a hospital merger, a post-acute facility, such as a hospice or a home health agency or a SNF. Pharma and biotech industries are often on those high billion-dollar end transactions, but we also do a lot of work in professional services industries, which go from PT all the way up to physician groups, with each different type of license having a little bit of a nuance to it. But the common thread through all of those industries is that, or at least in healthcare, outside of pharma and biotech, is that a lot of the secret sauce is actually in the employees and the provider group that are providing services, and that's what's getting paid for. And to sort of further elaborate on that, each deal is a little bit different and each size is a little bit different, but particularly in the professional services industries, physician groups, PT groups, dental groups, actually veterinarian groups, the structure is very important for us. And it varies pretty considerably if you're adding a platform, which is already complying with what we call the corporate practice of medicine, or if you're starting a new transaction for a practice that is outside of that today. The nuance there is that many states have rules that don't allow business corporations to employ licensed professionals to provide professional services directly. So you have to structure a transaction that keeps the employees at a professional entity like a physician practice and set up a management company that provides services to the physician practice so that they're able to participate in the economics of the practice going forward. That involves a lot of nuance. And one of the areas where we run into that nuance is, of course, restrictive covenants. The covenant has to sit with the employee at the practice, and it's the practice's covenant to enforce. So the nuances on the professional services side abound and vary considerably depending on whether we're adding a new practice to an existing platform or have to set up that platform to start.
So, Dan, when you're working on a transaction or conducting due diligence in one of the transactions that Tim just described, what are your clients most focused on?
There's a host of issues that our clients are looking at when they're considering a transaction, or if they're have already signed a letter of intent or definitive agreement to move forward with the transaction. I think three key issues, parlaying off what Tim just said, is the first is the structure. Is the organization structured appropriately so that they're in compliance with corporate practice laws, or will there need to be some restructuring before the deal? The second is, from a healthcare standpoint, we look at regulatory issues and making sure that there's no showstoppers or red flags. Types of issues there is whether they're running afoul any of the fraud and abuse laws that exist, including anti-kickback, Stark law, and the like. And the third issue that we really often focus on is the workforce. And I think Tim had mentioned it, but the restrictive covenants are key. The restrictive covenants often will sit with the practice and not necessarily with the management company, but evaluating the workforce and how the integration would look post-closing and seeing what covenants might exist with their current professionals and how those would be enforced likely by the practice as opposed to the management entity.
And so, Dan, kind of flowing from that, with almost all of your deals that you're dealing with, that's requiring to secure certain key employees. But are there particular types of healthcare transactions, some of which you've all just sort of walked through a little bit, where that might be more important than others?
Certainly. I know you had mentioned it earlier, but human capital in the healthcare space is oftentimes the most important piece of the deal. In a lot of the healthcare deals that Tim described, the physical asset to what they're pursuing are the human capital and the professionals that are providing the services. Sometimes in the life science industries, there can be a product, a physical asset, whether it be a drug or a device that might be sought after. But in somewhat the pure healthcare deals, it's the actual professionals that they're investing in so that they would be most concerned about in terms of ensuring and securing these people post-closing. Oftentimes, our clients are looking to make substantial acquisitions or investments with the hopes of increasing productivity and profitability. And the key in the healthcare space is ensuring that your professional workforce, whether it be physicians or physical therapists or other different types of professionals, are available and will be providing those services once the deal is closed. So evaluating the restrictive covenants that may be in place, how they may be impacted in connection with the deal, is a key part of the process and a key part of our diligence.
Tim, this is Erik. Curious what you do when one of these human capital intensive deals lands on your desk.
Well, it's funny, Erik, when we run into a restricted covenant problem with one of these deals, and almost always, particularly in the professional platform, we run into at least an evaluation of their restricted covenants. I have, as of late, walked down the hall to either Kate or your office, depending on which one of you was not on the phone at the time, then put it in front of you to see where we should start. It's very helpful to have you guys in the office, and it really allows us to work together to resolve these issues. But typically we request current employment agreements and see what kind of tools are in place today and start to think about what types of tools we could put in place in the future, at which point we turn to you or Kate and ask, the nuances of the particular area that we're in comes to mind. I talked to Kate last week about Florida. There's different laws in each of these states. So we turn to you and then let you take it away. So let me turn it around and ask, what do you do after we put it on your desk?
Great question. The first thing we want to do, as you mentioned, is gather the documents, the employment agreements and other documents. We want to know where the restrictive covenants actually are. They're not always in an employment agreement. They can also be found in a standalone non-compete or other type of restrictive covenant agreement. They can be found in a long-term incentive program. They can be found in all sorts of places. And actually, they can be found, depending on the company, in both electronic and hard copy form. So we really want to make sure we grab the full universe of these documents. Another wrinkle that sometimes comes up is if the company has done acquisitions in the past and the restrictive covenant agreements from that deal are housed elsewhere. They haven't updated them since. So we want to start with that. We want to make sure that they are compliant And then we want to know as much as we can about the workforce, in particular, the key employees that we're trying to secure. We want to essentially get an employee census, and we want to know their titles, their roles, where they're located geographically. As you mentioned, different states have different laws for non-competes and other restrictive covenants. We want to know whether or not they'll be receiving new equity in the acquiring company, or if they'll be rolling over equity, because that can be an important issue in particular in certain states. And we want to know the type of information or the types of information that these folks have access to. If they have access to certain confidential information and trade secrets, we need to make sure that's protected. And one of the points of asking for these documents, obviously, it's so that we can analyze them and make sure that they're compliant and that they are there. But another reason is just whether or not they exist. It could be a huge red flag if you've got a company with all sorts of employees that have access to either confidential information and trade secrets or customer relationships, and none of them are subject to even a confidentiality agreement, much less a non-solicit or a non-compete. And that could be a big issue, not only because obviously you want to have that in place, but also because it shows that they're not really taking the issue seriously. And if you're the acquiring company, you start to wonder, what else are they not doing to protect their information? Because if you want to be able to enforce your trade secret rights, one of the requirements under both state and federal law is that you've taken reasonable measures or reasonable efforts to protect your trade secrets. And if the company you're acquiring hasn't been doing that, then the asset you're purchasing may not be worth very much, because their information may be out there. There may be other competitors that are already getting in the game using their information, and so on and so forth. If it's an asset deal, I also want to take a look at the assignability provisions. If it's a stock deal, it's less important because you're stepping into the shoes of the acquired company. But at the end of the day, really what I want to know is who's important, who's a flight risk, who's a threat if they go to a competitor, and what kind of documents and agreements do they have in place to make sure that these folks will stay.
That's great, Erik. And oftentimes the targets don't love us asking for all the different papers, but it's part of the process, and it really serves our clients' interest to have that on the front end. And usually from Tim and I's perspective, once we have that paper, we'll chart those out and have it documented so that we have it in one place and understanding the full universe of employees in the census and what restrictions may apply to them. Kate, once you have all the information, all the documents that are made available that Erik referenced, what do you typically suggest to clients as ways to secure the employees that are identified as being key or really important to have post-closing?
Yeah, so we try to come at it with a few different approaches. Part of it is based on the type of organizations that we're dealing with in these transactions, and also the number and type of key employees that we're talking about trying to secure. But generally speaking, coming at it from, if you will, like a carrot and stick approach, where you're in one part wanting to create incentives for employees to stick around post-closing, and then also some tools to ensure that if they do leave, what happens then? So as it relates to the sort of carrot approach, using certain tools post-closure, like retention bonuses. Sometimes those are retention bonuses that are paid out soon after closing. Sometimes they're staggered with 6 months to a year. And of course, those will differ depending on the level of the individuals within the organization. Some of those are agreements, frankly, that are going to exist before the transaction occurred anyways, where key individuals would already have had that as part of their either employment agreements or shareholder agreements. But there are other things that, as the buyer, will want to do is to enter into those as part of the transaction. And then maybe also, depending on the organization, equity grants, stock options, or ability to purchase stock options are other ways to incentivize individuals to stay. Also, things like softer approach of enhanced benefit plans or other type of cultural changes that are disclosed to the employees as part of that transactions. Other things that can happen sometimes, and really, again, it's going to depend on the buyer's needs and their desires, but sometimes to change individuals, for instance, that were previously at-will employees, to providing them some type of guaranteed employment post-closure, with many times carve-outs for certain type of termination for cause type provisions. So that's one way to get at it from the incentivizing employees. And then there's the stick approach, which is more of an approach if someone is going to eventually leave your organization, putting some restrictions on the way they leave. And that would be really looking at what we're talking about today, which is restrictive covenants. And so whether that is a non-compete, if they're in a location where you can create an enforceable non-compete, or non-solicitation of customers or employees, which of course can be really critical. And then, of course, finally, confidentiality agreements prohibiting and preventing the disclosure of confidential information and also really keep trade secrets as well.
I really like the carrot and stick approach, combining them two, but do you find one works better than the other, or is there a recommendation that you give to companies to use?
Erik can talk about this as well, but I think some of it depends on the type of the organization and the specific employees involved and the level involved. Of course, you're going to have certain individuals you may not provide equity grants to or the potential for stock options. But in a perfect world, I think both is the preferred way if you can do that, because one, you're incentivizing people to stay in the first instance and wanting them to continue to be part of that organization. But we also realize the reality is that people will eventually move on at some point, and you want to ensure you're protecting the goodwill of the organization, the customers, and of course, ultimately revenue and profits. And so being able to combine both of those, I think, is preferable.
I would agree wholeheartedly. I think no matter how good your restrictive covenants are, you can't force somebody to stay with your company if they don't want to. We did away with indentured servitude a long time ago. And also you want the employees to want to be there because that's really what's going to retain them. So if it is appropriate to give them stock options or grants, especially those that don't vest for several years, or some sort of retention bonus that doesn't come due for a few years, certainly want to try that. And there's all sorts of non-monetary incentives that you can provide as well, whether it's benefits or cultural things. A lot of disruption happens during an acquisition on both sides. And so you want to do as much as you can to keep both the employees of the target company on board, but also your own employees. You got to make sure that they're not hearing rumors and starting to think that they're going to be laid off, and they don't want to see that the acquired companies' employees are being treated better than them. That's going to create some weird dynamics. So agree with Kate wholeheartedly. You want to do both.
And that's where we come in, particularly on the incentive side or the carrot side. In the healthcare space, there are restrictions on what you can do for providers or for companies that are providing services that are getting reimbursed by the federal government, be that the Medicare program or the Medicaid program. In particular, the Anti-Kickback Statute, False Claims Act, and Stark statutes come into play, which really do limit what we can do for providers on the carrot side. So we spend a significant amount of time thinking about how to create compliance structures to get things like stock grants to providers. A lot of that is going to be determined by the type of services that they are providing and the space that they're in. If there's a lot of DHS, the Stark law becomes a much bigger concern, and how we structure the transaction and structure the company to allow for employee incentives is very important. And in addition to the great carrots you talked about earlier, Kate, a lot of time is spent on thinking about just base compensation and how that is going to flow in the professional services side, particularly in the physician side. We spend a lot of time thinking about the best ways to help our clients, particularly private equity clients, are very keen to figure out ways to incentivize productivity from providers in a way that is compliant and maintains high quality of care being delivered. So it's very fun to hear you guys talk about how you think about the sticks and carrots, because we see them, carrots in particular, as potential risks that we have to think through and come up with different ways of delivering the same goal that you might have outside of the healthcare space.
Well, and I think that's particularly true when you have employees of the target, right, of the seller, who may already have certain, for instance, profit sharing or incentive plans in place, and they want to continue to see that move forward or increase. And then what are the buyer's desires and whether that makes sense, depending on if they already have key employees in place on the buyer side, or whether it's, again, private equity purchasing an entire new entity. So there is that tension a little bit of incentivizing people to stay and either keeping it the same or increasing what they're already receiving so that they feel comfortable moving forward.
Right. And what we run into is folks want to keep what they have currently, and sometimes that's not a compliant structure. For our clients, we can't advise them to keep that type of structure going forward. We also can't give those providers who are billing programs, the public programs, something for nothing. So we sometimes have to figure out a way to deliver value from the provider to where our clients are investing so that we can then put a different carrot that is compliant in place. And I know that I've run to both you and Erik about maybe there's a restrictive covenant that we can add a stick that is worth value so that we can add a carrot to that provider contract.
This is all really interesting. It's not anything that Kate and I really have to think about in other industries in terms of the Stark Law and kickback stuff. So it's really good to have you guys on the team. Dan, as part of the diligence process in one of these deals, what challenges do you find in how restrictive covenants are structured, both in terms of the specific provisions, but also in terms of how they've been dispersed amongst the target company's employees?
One of the biggest themes that we see when evaluating restrictive covenants in the healthcare and professional space is the lack of uniformity. And I think a lot of times that stems from what Tim described earlier was sometimes tuck-in acquisitions or platform deals, is that there might be one entity that started and they have been aggressive and have gone out into the market and have acquired different physician practices. And there can be a wide variety of the restrictive covenants by different practice. So sometimes when you're evaluating an entity's physician's restrictive covenants, there could be some ones that are in strict compliance and others that are just completely outside the lines of that state specific law, and understanding how are we going to bring these into uniformity if this is what we want to go after. We want these providers, but their restrictive covenants are wildly different by practice, by state. So that's one thing that we often see. And then the other thing, going back to kind of the health regulatory considerations, is just the corporate practice issue. Different states have different laws, like restrictive covenants vary by state. California is different than Massachusetts. Corporate practice varies by state. Some states have corporate practice restrictions, meaning the professionals are employed by a professional entity and it's not a general business entity. So understanding who has the ability to enforce the restrictive covenant is key, because although the entity that may want to enforce it may not actually be considered the actual employer here. And I think the last theme, in kind of going back to the carrot and stick approach that you guys had talked about, is striking the balance of patient choice. You don't want to be seen as an employer that wants to aggressively enforce restrictive covenants, and especially in the healthcare space, because people want to have the ability to choose their provider and go to the provider of their choice. But if they're being sidelined by a restrictive covenant, it can be a deterrent from other physicians that you might be trying to recruit. So there's a host of issues that we evaluate when conducting these diligences.
So Kate, we've identified a key employee. How do you help, or how do you advise buyers on how to structure their restrictive covenants for the key employees once they've been identified in a transaction?
So part of it is taking into consideration what Dan was just talking through, is sort of like, what can we do? First of all, let's start from there, right? What can we do as the employer, and what do we want to do, and understanding that end game goal first off. From there, also analyzing what protections are maybe already in place, right? So what restrictive covenants have these key employees already executed with the seller that we may be able to use going forward. And part of that is who has non-competes, who has non-solicitations. Do these key employees already have NDAs, confidentiality agreements in place? Hopefully, yes. And then again, going back to Dan's point, where are they located? Because that very much going to differ. If you're in California versus Texas versus Colorado, all of those things are going to be different. So knowing those key things is all part of that process. And then taking all those factors into consideration along with the industry piece of it. Because again, analyzing this for a physician group acquisition versus, again, a pharma company is going to be very different. And then determining what kind of deal it is. And you all know this better than we do, right? Whether we're talking about an asset deal or whether we're a stock deal. Is the buyer really taking over as the new organization, or do we need to talk about assignment of pre-existing non-competes? Do we need to talk about a restrictive covenant that is triggered, which we can talk about in more detail, that's triggered post-closing, or are we talking about a non-compete that we want triggered post-termination of employment? We look at sort of all of that and then make a determination about how we then want to structure that for those key employees.
Erik, Kate mentioned those key employees and how you want to structure it. What would you consider in terms of factors if you wish to impose new restrictions for some of those key employees? What factors would you think would weigh in favor of imposing new restrictions on those employees?
So one thing you want to look at is the level of the employee and their access to your client information, your customer information, your patient information, your own company's confidential information, and of course, customer or patient relationships. Different levels of employees can be treated differently, and in fact, should be treated differently. Non-competes not worth the paper it's written on if it's not protecting a legitimate business interest. You can have anybody sign a non-compete, but if it's not protecting either trade secrets and confidential information or what we call customer goodwill, which is relationships with your customers, patients, et cetera, then it's not going to be enforceable. The other thing you need to think about is where the folks are located. As you mentioned, as Kate and Dan have both mentioned, state law governs non-competes currently, and it differs widely from state to state. I think everybody knows California prohibits non-competes. You probably don't know that North Dakota and Oklahoma also prohibit non-competes. And in this space, in particular, when we're talking about healthcare practitioners, doctors, nurses, sometimes even social workers, there's a handful of states that prohibit non-competes specifically with those types of workers. For instance, Massachusetts, you can have non-competes for typical employees that are reasonably tailored, but you cannot have them for physicians, nurses, social workers, psychologists, and other classes of employees, typically the practitioner types. Because going back to what Dan said, there's this sacred relationship between a physician, for instance, and a patient. And the state recognizes that as public policy and wants to protect that. And there's many other states that do that as well. And in fact, it's been a trend since COVID to focus more on these frontline healthcare workers for a variety of reasons. And in one space, it's passing laws that either restrict or prohibit altogether non-competes for them. There's two real trigger points when you're talking about non-competes or other restrictive covenants in connection with the sale of a business. You've got the post-closing non-competes, as we've call them, and you've got post-employment non-competes. The post-closing non-competes typically are limited to the seller of the business. So it's the person who holds the equity or the people who will hold the equity. And there's different tests in different states for what the threshold is. Typically, it's the larger holders of equity. And for those folks, even in California, even in other states where they prohibit non-competes, they permit oftentimes sale of the business non-competes, because the thought process is it's not an employee that you're saying as a condition of employment, you have to sign this, and the employee can obviously decide to go elsewhere, but they've got limited bargaining power. When you're selling a business, oftentimes the sellers are receiving handsome consideration, millions, if not tens of millions of dollars. And what they are selling is the goodwill in their company. And the buyer's not going to buy the company if the seller can just go out and immediately set up across the street a competing business, going after the same customers, using the same information, the same business strategies, and so on and so forth. And the states, even California, recognize that and allow that kind of restrictive covenant in the connection with the sale of a business. Now, that type of agreement we recommend goes in the purchase and sale agreement, not in the employment agreement, even if it is tied to the sale, just because you want to, if we're enforcing these in court, you want to be able to draw that distinction between this being an employment non-compete or post-employment non-compete and a sale of the business non-compete. The other trigger point is obviously when an employee leaves. And that you want to make sure you've got both the sellers, if they're going to remain employed, and key employees who are non-sellers, whether they're managers or top performers or people with access to the secret sauce. Unlike post-closing restrictive covenants, it is more difficult to enforce a post-employment restrictive covenant, in particular a non-compete. The courts are going to look at them more skeptically. So you want to make sure that they are narrowly tailored to protect the legitimate interests that I talked about. And you're allowed to stack these types of agreements, meaning that a seller can have both a post-closing non-compete, let's say that's 5 years, and then a post-employment non-compete, and let's say that's 1 year. An example of this that I could give is if you've got a physician group and it's owned by the physicians and they're selling the practice to a private equity firm in a state that allows non-competes. I'm going to ignore for a minute all the corporate practices stuff that you guys talked about. You deal with that. But from my perspective, if those physicians are going to remain employed by the new entity, you want to have them sign the post-closing non-compete, assuming it's allowed in that state, say for 5 years. But let's say that they stay on for 6 years, 7 years, 10 years, and then they want to go work for a competitor. Well, you want to have protections at that time too, because even past the first 5 year post-closing, they still have access to your information. And of course, in the patient-provider space, there's a concern about patients following providers who have left the practice. So you want to have both of those types of agreements that are post-closing and then post-employment. And then, of course, for the key employees, you would just have the post-employment. Certain states, as I mentioned, like California, when you're talking about the key employees who are non-sellers, you're going to have to be more creative. And you could tie it into, I've done this in the past, either giving or rolling over equity. It's too complicated to get into in the short time we have here, but there are ways of doing it, or using choice of law provisions. And it's also a good time, by the way, unrelated to the acquisition, directly to make sure your own house is in order. And we talked earlier about how your own employees, you can't forget about them too. And you can't be treating the new employees better than the old ones. But at the same time, you want to make sure that the employees that you have currently are subject to non-competes, because again, there's a lot of disruption. They hear rumors. There's going to be, every time there's a deal, it gets out in the market, headhunters come calling. So you want to make sure that your own folks are lined up and locked in as well at this point in time.
So Dan and Tim, any parting words of wisdom for whether it's in-house counsel or HR professionals or other high-level stakeholders at healthcare companies who might be listening to this podcast?
I think Erik actually hit it exactly when he said, I'm not going to worry about the corporate practice and medicine stuff. I'll let you deal with that, because it really is a holistic approach where you have both experts in restrictive covenants and experts in what are the healthcare laws that govern the carrots that can be offered to employees that need to be thought through when you're going to incentivize and maintain a workforce that either has trade secrets or that special sauce that makes the company special or valuable, or they can be the economic engine, like the circumstances of professional practices. There are no widgets here. They're what makes the company work. It's just physician services or professional services from PTs or dentists or veterinarians that are what make the economic engine of the company run. So you have to think about it in both ways, both compliance with restrictive covenants and drawing them in a way that is both useful and will maintain their usefulness over time, and maintaining compliance with the federal laws around incentives for professionals.
And just to add on to what Tim said, like he said, it's a holistic issue. And for our client's sake, I wish it was a very simple read and analysis, but it's not. And I think especially as discussed on spilling secrets, especially in the light of the FTC's proposed rule with respect to non-competes, it's only going to continue to be an issue that needs to be analyzed. And there's a big policy shift of pro-workers, pro-professionals, and evaluating non-competes for healthcare professionals will only continue to be an issue that's worth analyzing. And luckily, EBG has the twin practice that I think lends itself to it.
Yeah, I absolutely agree. Thank you, Erik, Dan, and Tim. It was a lot of fun doing our first crossover episode of Spilling Secrets and Diagnosing Healthcare, and I look forward to collaborating with you all in the future.
Thanks, Kate. Thanks, Dan and Tim.
Thanks, guys. Really appreciate the time.
Thank you.
A special thank you to our listeners. If you would like to subscribe to either or both podcasts for free, please go to ebglaw.com/subscribe and click the box for Trade Secrets and Non-Competes Spilling Secrets podcast series and the Diagnosing Healthcare podcast series. And be sure to keep an eye out on our Trade Secrets and Employee Mobility blog at tradesecretsandemployeemobility.com and download our new 50-state non-compete survey. Thanks again for joining us. Until our next episode, this is Kate Rigby and Erik Weibust signing off on behalf of the Spilling Secrets team.
And this is Dan Fahey and Tim Murphy signing off on behalf of the Diagnosing Healthcare team. Thank you for listening today.
Thank you for listening to Diagnosing Healthcare. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare and life sciences, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.